Hello and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt, and today I'll be discussing IRS and Department of Labor relief from certain employee benefit deadlines during the COVID-19 crisis. The DOL and the Internal Revenue Service have issued COVID-19 extensions to certain timeframes under ERISA and the Internal Revenue Code. These extensions apply during the what's so-called outbreak period, which runs from March 1st, 2020 until 60 days after the announced end of the COVID-19 national emergency. Essentially, during this time is standing still. It's as if we are in a science fiction movie and time has stopped for purposes of many ERISA and Internal Revenue Code deadlines. So let's try to get into some specific provisions. First of all, HIPAA. So HIPAA requires group health plans to provide special enrollment rights to individuals who have birth of a child, adoption of a child, marriage, or they lose other health plan coverage that they had before the beginning of the plan year. Under HIPAA, an employee has 30 days after the event to elect special enrollment, mid-year enrollment into the group health plan. Under the guidance, the 30-day period doesn't run until 60 days after the end of the announced termination of the COVID-19 national emergency. So if an employee experienced a HIPAA event, had a birth, a child is born, or the employee gets married, during this period of time, from March 1st until 60 days after the end of the COVID-19 national emergency, the 30-day period will not start to run until the end of that 60-day period following the end of the national emergency. So this could be a very prolonged period of time where the clock is not running, and employees will have additional time to make a retroactive election or to make an election of group health plan coverage. This rule also applies to COBRA. So normally, if an employee has a COBRA qualifying event, the employee loses coverage because the employee is terminated from employment or has a reduction in hours of employment or experiences one of the other COBRA events, such as a divorce. The deadline for the employer and plan administrator to provide a COBRA election notice to the employee is 44 days after the qualifying event. Just like the HIPAA deadline, that time is standing still. And so that 44 days won't start to run until the end of the 60 days following the end of the national emergency. Additionally, qualified beneficiaries who have the right to elect COBRA and pay premiums, their deadlines are not running either. So normally, a qualified beneficiary has 60 days after the end of after receiving the COBRA election notice to elect COBRA, and then has 45 days after electing COBRA to make a retroactive premium payment for the coverage. So if you think about it, we're still in the middle of the COVID-19 national emergency. As of the recording of this podcast, we really don't know when that's going to end. And then when it ends, the deadlines will start to run 60 days after the announced end of the COVID-19 national emergency. So the 45-day period for making COBRA payments, the 60-day period for electing COBRA. If a COBRA event happens during this period, during what's called the outbreak period, the clock doesn't start to run until 60 days after the end of the national emergency. So employees and qualified beneficiaries have a much longer, extremely longer period of time to make these elections. One concern that for plan administrators and employers is the extent to which an employee wants to make a retroactive election. So upon the birth of a child under HIPAA, employees can retroactively elect coverage to the date of the birth. Or for COBRA coverage, the employees can retroactively elect COBRA coverage back to the date of the qualifying event. Now, when we're talking about a 30-day election window or a 60-day election window or 45 day payment deadline, the period of time between the date the employee is going to elect and start paying premiums and the retroactive date that coverage begins isn't all that long. But because of this outbreak period relief, that election could occur 6 months. It could occur, who knows, a year after the date of the qualifying event or the date of the HIPAA special enrollment event. And so unless the employer is going to forgive the COBRA premiums or forgive the group health plan premiums for the HIPAA election, it may be very difficult for employees to pay for the coverage retroactively. So even though we are in this outbreak period relief, it's important for employers to communicate with employees and let them know that you have an extended period of time to make these elections, but you're going to have to pay for the coverage. And so the longer that the employee goes without paying, the more difficult it is for the employee to make those back premium payments. The relief also applies to ERISA claims and appeal procedures. So all the deadlines for filing claims and for filing appeals to claims denials, those time periods are not running during the outbreak period. And also, the IRS and DOL has provided relief from providing required notices and disclosures. So as long as a plan administrator is making a good faith effort to communicate with participants, if they know that the participant has email or text, as long as they're trying to somehow communicate with participants, there will be no enforcement action for missing the deadlines for various notices and disclosures required under ERISA and the Internal Revenue Code. So just the list includes things such as summary plan descriptions, summaries of material modifications, summary annual reports, summaries of benefits and coverage, annual funding notices, and participant fee disclosures. So that provides relief to employers who are really having a difficult time during COVID-19 of communicating with employees. So these are just some of the examples of the relief that's currently available. Again, it's important to know that employees have extended deadlines to make elections, but it's also important to be communicating with employees and making sure they're aware that the rules as far as paying for coverage still apply. So even though they have an extended period of time to make elections, it may not be practical to wait until 60 days after the end of the national emergency. That will wrap up our discussion. Thank you for joining me on this episode of Williams Mullins Benefits Companion. If you're in search of more COVID-19 related legal information, visit williamsmullin.com and click on the COVID-19 Legal Resources link in the ribbon on our homepage. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullin.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.